Good morning, friend. I fortunately received a query from one of the inquisitive lawyer. The query was from where a junior lawyer should start practicing and on what places the internship be conducted, whether from high court or from trial court. My dear learned friend, the answer to this query is simple. It lies in the field selected by the lawyer. If the lawyer chooses to practice at civil court, trial court, the answer is that he should start there. If a lawyer has in his mind that he has to do practice at high court, then the choice is that the lawyer should start from high court. If a lawyer intends to start at Honorable Apex Court, then he has to start practicing at Apex Court. Let us take the example of civil court or trial court. The lawyer has to decide first whether he chooses a line of civil side or criminal side, because since long the major distinction is between the two, civil or criminal side. And in case the junior lawyer is not in a position to distinguish between the two or to take a proper decision with regard to the side of practice, line of practice, then it is optional that he should visit the trial court, meaning thereby civil court and criminal court both, should make friends there, should listen to the pleadings and arguments, should correlate the sections of the relevant act, code. That means the lawyer should first allow him to freely visit all the courts without being prejudiced, and over a period of time the lawyer should evaluate his own interest. If it is inclined towards civil side, then of course choose the civil side. Enormous scope is there, lot many acts are there, lot many courts are there, and if inclination is towards criminal side, then the lawyer should go towards criminal side. I am concentrating on trial court right now. Now this is the situation one. Now if the lawyer is in a position to decide before entering to the court that he would prefer say civil side, then the option is available before him at the civil court, district courts, and also in various other courts which have come up recently, which I may just line up. For example, the Motor Accident Claims Tribunal dealing in the Motor Vehicle Act 1988. Employees Compensation Commissioner Courts dealing in EC Compensation Act 1923. Consumer Forums dealing in Consumer Protection Act 2019. Family Courts dealing in family disputes, marital disputes, maintenance question, such as relevant sections of the Hindu Marriage Act or section 125 of CRPC for maintenance, etc. Domestic Violence Act. Other examples of the courts are Debt Recovery Tribunal, where DRT Act of 1993 and the Surface I Act of 2002 are dealt with. Excise Tribunal dealing with the excise matters. Income Tax Tribunal dealing with the income tax matters. Commercial Courts dealing with the Commercial Courts Act. Labor Courts dealing with the Labor Industrial Disputes Act and Code of Wages, such as Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, etc. National Company Law Tribunal dealing with the Company Act and Insolvency and Bankruptcy Code of 2016. Education Tribunal dealing with the education matters of teachers and others. UP Public Service Tribunal dealing with the state employees matters. Central Administrative Tribunal, which deals in the CCS and CCA rules, Central Civil Services Classification, Control and Appeal rules. In such scenario, the lawyer has to select first whether it is district court or the various tribunals or the courts. Initially, a lawyer must visit the courts and must read minimum 10 cases related to that act and the code thoroughly. I am emphasizing on this point. Before that, I must take up the second part of the question, which says that whether High Court. Yes, the practice can be started at High Court. Earlier notion was that our elder and most experienced and senior advocates have suggested that before approaching the High Court as a practitioner, one should first spend a substantial time, say 3 years or more, in the district courts, to apprising oneself with the pleadings, argument, codes, law, and other things. The concept has changed. I believe that one can directly start from the High Court. What he has to do, he has to train himself. He has to understand about the pleadings, about the arguments in the particular court. Say, the very basic question which arises in the mind of a lawyer, that when so much option is available, then how to proceed? Yes, this is important. See, first and foremost quality of a lawyer is, which is required, is that lagan, focus, concentration, willingness. Then he can proceed by selecting 10 simple cases. That means lay hand upon 10 simple cases, complete pleadings where the petition, written statement and counter and rejoinder have been completed. One by one, read thoroughly all these cases. Let us example the very first case. Read from the very first line the pleadings, under which section the petition has been filed, how the parties are made, how the petitioners and respondents are chosen, how the opening line is started, and then the entire story, the case law referred thereto, a relief, then the reply filed by the respondent, then the replication filed by the petitioner. Like this, minimum 10 case files should be read thoroughly. Then make oneself available in the court room for court hearing, argument hearing. Minimum 1 month is required to be deputed for hearing. These two things will help a lawyer to train his mind. In fact, he has to help his brain open up a file, a folder, in which legal pleadings and legal argument are to be entered. And this process has to go on throughout his career as a in legal profession. Because the more he reads, the more he listens, the more he argues with his peers and in the courts also, the more his brain becomes matured, more he becomes a matured advocate, the more he becomes experienced, and more his pleadings and arguments become refined. So there is a basic difference between the knowledge and the experience. Knowledge, a lawyer is entering into the profession with enormous knowledge, which he has learnt in law colleges. But the experience comes with the practice. When a lawyer starts and prepares his own case, from the pleading, from section, from relief, then receives rebuttal and then properly deals with that rebuttal in the replication, and also prepares argument, places argument in the court, deals with the query of the court, and comes out with the result, maybe positive or negative, then that is a practical experience, in practice experience. And the more he practices, he becomes a practicing advocate and his mind becomes more matured. So knowledge may help a lawyer to work as a base foundation, but only practice will make him an advocate. So regular practice and regularly hearing the argument, reading the cases, pleadings, preparation of cases, arguing with the peer advocates will make a lawyer a strong, matured, experienced advocate. I said 10 cases. Now let us go ahead. 10 difficult cases. The second phase is of 10 bulky files consisting of more complicated questions of law, reading the entire pleadings, studying them, studying the related laws also. Again, spending whole time, daytime, that is court hearing time in the court, and also discussing the relevant points with the peer advocates. This will keep on helping the lawyer to become an advocate, and this method has to be adopted in any court of law. Any court of law. I have given a reference of number of courts, tribunals. So wherever a lawyer starts, he has to adopt the same technique. By adopting this technique, a lawyer becomes more adept, expert, and experienced. The more he is experienced, the more number of clients will approach him. More his name will spread. Now, another part of the query is that the internship. Internship, that means a place to get a practical experience. Internship may start at a chamber of a senior lawyer, experienced lawyer, or if the lawyer is placed at a metropolitan towns, then and also needs employment in the beginning, then law firms are the best opportunity. The lawyer can start with the law firms where he will get employment, will get sufficient remuneration also, and will get enormous opportunity of learning the things, preparing the drafts, correlating the judgments, studying, and very many things, and also assisting the seniors in the firm. Now, another option for the internship is that first and foremost, a lawyer should choose a senior advocate, experienced advocate who has got cases of various courts. In such situation, what he gets an opportunity is that such senior lawyer, since he cannot appear in all the courts every day, then he needs a junior lawyer and on whom he can entrust responsibilities of placing the pleadings, making short arguments also in different courts on the date fixed. In such situation, a lawyer will get enormous opportunity of visiting different courts, various courts, will also be able to lay his hands upon the various pleadings, since in most of the cases the pleadings in different courts are different. The lawyer will also be able to lay his hand and develop experience and knowledge in different acts, codes, and would also have an opportunity to place his arguments, prepare pleadings also. While preparing pleadings and after preparation of pleadings, the lawyer should definitely consult his senior advocate. So once this opportunity is there, avail it. Or where there is no such opportunity, then the lawyer should first choose his line of action and then should join a chamber for internship of 1 year, 2 year, 3 years, in which he is inclined to start his career, say civil side, revenue side, practicing in different tribunals, courts, criminal side, etc. So join a chamber where there are abundance of cases of that nature. Say it's senior chamber of criminal side, senior chamber of civil side, senior chamber of serviceman side, So now, but once a lawyer comes to the High Court and starts his career from the High Court, see, there is no limitation because High Courts has to seize the petitions of different acts, including service matters, including cases coming from the tribunals, where High Court is the appellate authority. High Court also deals with the petitions under Article 226 of the Constitution of India, where criminal side petitions like habeas corpus, as well as civil side petitions like mandamus, certiorari, overturn prohibition are used. In High Court, he has to um, study the criminal side cases also. So, lot many opportunities are available at High Court. At High Court also, the internship may start with a chamber which is dealing with one particular type of cases, say civil side, criminal side, service side, original jurisdiction, etc. The main answer to the query is that after spending initial period in the various courts, a lawyer has to frame his mind and decide in which side he has to practice. And once it is decided, then join a chamber for experience. So, upgrading his knowledge by reading the pleadings, by studying the relevant laws, by hearing the court arguments, and then preparation of his own cases and placing his own argument before the court, dealing with the queries, always prepared with the concerned laws and judgments, always inclined to add on experience. This will make a lawyer a full-fledged, experienced, lovable advocate, popular in the clients, popular in the peers, popular in the staff, popular among the courts, because everyone likes a person who is thoroughly and meticulously prepared and presents his argument on substantive materials. Thank you.